Hi guys, welcome back to my channel. My name is Jane Okoye and today we're going to be talking about protecting your brand, trademark and intellectual property for creatives. So as usual, creatives fall under the umbrella term for artists, producers, sound engineers, songwriters, dancers, content creators, people that just create things. Shasha. Let's jump right into today's video. Guys, so the first question is, why is it essential for artists and creative professionals to understand and utilize trademarks in protecting their brand? So trademark plays a very important role in distinguishing your brand from my brand. So the brand that Wizkid has is different to the brand that Davido has, is different to the brand that Chris Brown has, is different to the brand that Beyonce has. Like you create something and it's like you are the original creator of that, you trademark it because someone else can come up with it and claim to be the owner of it. But once you create something, you can trademark it to protect your brand. And it also helps in fostering brand recognition and preventing confusion among customers. So if I know that once I hear this beat, that's that producer, or once I see that video, the way the video director or creative photographer or videographer shot that video, I know that that's the person that directed that video. This is this person's video. Like there are things in there that you can trademark: your front, your name, the beat, the sounds, whatever it is that you could trademark. And so by securing a trademark, artists can establish like an identity and protect their brand and their creative work by trademarking their stuff. So let's go on to question 2. The second question is, what steps can artists take to effectively secure trademarks for their creative work? And how does this process contribute to long-term brand protection? All right, so the trademark, I think that's such a complicated word. The trademark process or the registration process, you have to thoroughly research to make sure that no one else has actually come up with that idea that you feel like you're the original creator for. And then you now fill out the application form to the necessary authorities or necessary authorities. And then you now actively monitor to see if anyone will try and trademark that same thing and file legal actions. Usually people just get a lawyer to like trademark or that go through the research process, trademark it, monitor it, and just follow it up to just ensure that nobody is infringing on the right that belongs to you or using your creative work to make money for themselves without you gain anything in return or from that. So it also allows you that if someone actually does infringe on that right, you have the legal backing to be like, look, I trademarked this, it's mine. You can't use it. So I feel like that's something I always tell people that design fashion, like fashion shoe designers, trademark your work. If you know that it's a creative thing that you created, like that idea was given to you by God Himself, and you sat down, sketched everything, or you came up like created the terms of the B, whatever it is, like that's your work, trademark it. Ensure that it's trademarked. And if someone tries to use that, sue them and get money back because don't try to play with my work. Like to sit down and create something, it's a long process. So ensure that you trademark your work and it actually prevents infringement and protects the integrity of your brand long term. So let's go on to the next question. The third question is, in the realm of intellectual property, how can artists strike a balance between sharing their work with the public and maintaining control over its use to prevent unauthorized exploitation? So in the case of, I really want to share my work with the public, but I also want to control how that work is being used, you would go into a licensing agreement. So this gives you a level of exposure, but you also control how that works. So I might have like a song that I have written or whatever it is, and then I'm like, okay, cool, I can license that song to someone else or a brand to use for 10 years. And then after 10 years, the right returns back to me, and then I can do whatever it is that I want to do with it. And then if someone else tries and use that same song that is not yours, then I have legal backing to sue you for infringement. So it also helps to control the exposure that you give to that. It also helps with the revenue income coming in, because if you're licensing your work, you get paid to license your work. It's not for free. I'm giving you the right to use my image for the next year as an artist. So if I'm going to Pepsi or if I'm going to whoever to say, okay, cool, I'm your brand ambassador. You have the right to use my images for a year. After a year, that right returns back to me and you can't use any of my work. That's licensing. If I want to release my beat to someone else and be like, you have the right to use this for 5 years. After 5 years, whatever income that's coming from there comes back to me. That's licensing. So you have a license agreement between you and that party that you want to license your work to, and then you move on from there. It also you have to establish a clear licensing terms in to avoid kind of confusion on what they can use your creative work for, in the sense that some people will want their image to be used for social media, but when you want to use it for billboard, you can't do that. So if someone then goes ahead to use your image for billboard work and it's like, yeah, you weren't allowed to do that. It was clearly stated that these are the areas that you can use this image for as a photographer, but you went ahead and used it for this, which is an infringement on my right. So you can also sue for that. And it just helps to protect your brand overall when you have a clear term definition in the licensing agreement to help you control what narrative is out there with your work. Okay, the fourth question is, what challenges might artists or creative face in enforcing their intellectual property rights, and what strategies can they employ to address or mitigate these challenges effectively? So enforcement challenges may include identifying infringements, navigating the legal process, and then cost of actual taking it to litigation. So for creatives, to mitigate these challenges, you would implement proactive monitoring, sending cease and desist letters whenever you see someone using your work, and then introducing alternative dispute resolution to kind of sort out the issue. Sometimes you'll be like, all right, cool, we can actually talk about this via email, via phone call, Zoom, whatever. We sit down, mitigate, and be like, this is my work, please don't use it. But then if these dispute resolution do not work, then you can then take legal action to protect your work. All right, the next question is, beyond trademarks, what additional intellectual property consideration should creatives be mindful of to protect their creative works and brand? So in addition to trademarks, artists should consider protecting their works through copyright, patent, trade secret. So these are a few. Each of this intellectual property offers a different layer of protection, and when you have all these things in place, it gives you a kind of strategy that if someone was to use your work, if copyright doesn't protect you from it, trademark would protect you from it. If trademark doesn't, patent would. If it doesn't, trade secret, something, it gives you different strategies to use to protect your work and reduce the use of unauthorized use of your work. So yeah. The last question is, how can artists educate themselves and stay informed about evolving intellectual property laws and industry trends to adapt and enhance their brand protection strategies? Creatives can stay informed by actively participating in the industry like forums. There's a lot of those in Lagos that you can go sign up for. People will come in, lawyers will come in and talk about intellectual property, copyright, trademark, whatever the case may be. There's always workshops that you can sign up for to learn a little bit more. You can also attend legal workshops, that's what I just said. And then you can also seek advice from intellectual property lawyers or lawyers that are crafted and skilled in the intellectual property within the entertainment industry. So that's another way to kind of keep up to date with every single thing that is going on. Also, you have to regularly review laws around intellectual property, which is why I just feel like get an entertainment lawyer on retainer. They kind of keep up to date with all this stuff while you just focus on doing the creative work and your lawyer just handles whatever it is. And then if you bring something that could be an infringement on someone else's right, then I would tell you as your lawyer and be like, no, this won't work. As opposed to you trying to create songs and still doing research, it kind of just offloads from your plate if you have a lawyer on retainer. So yes, that are ways to kind of effectively protect your brand and ensure that you're not infringing on someone's right and someone is also not infringing on your right. I hope you guys really enjoyed this video. I will see you guys back here next time. And make sure you share this video to your loved ones or any creative person in your life that you feel like this video will be beneficial for them. I really appreciate you guys sitting through this and talking about boring law stuff, but that's what we love. So I'll see you guys back here next time. Bye, guys.